Right now, your family may be one missing form away from hearing 5 words at your bank that they never expected to hear. We cannot release the money. You may have spent 30 or 40 years building that account. Your children may know exactly where you bank. They may know where you keep your important documents. You may even have a signed will sitting in a drawer with their names clearly written inside it. And none of that automatically guarantees that they can walk into your bank after your death and take out a single dollar. One missing bank designation can be the difference between a relatively simple transfer and a family being told, "We are sorry. These funds cannot be released to you yet. There may be funeral expenses. There may be final household bills. There may be a mortgage payment due next week." The bank does not make an exception simply because your family is grieving or because everyone knows what you intended. And here is the part most seniors never discover until it is too late. Nothing looks wrong while you are alive. Your debit card still works. Your Social Security deposit still arrives. Your bills are still paid. The balance is still sitting there. So you have absolutely no reason to believe there is a problem. Stay with me because in the next few minutes, I am going to show you the account mistake that creates this situation, the beneficiary designation many banks use to help prevent it, the 3 mistakes that can make that designation useless, and the exact questions you should ask your bank before the end of this week. This is one of those financial details that looks tiny until a family is standing at a bank counter during the worst week of their lives. Here is the senior's briefing. Your will and your bank account do not always travel through the same process after death. A will is an important estate planning document, but some financial accounts can also have their own death beneficiary instructions under the account agreement and applicable state law. That is where the missing form comes in. At many banks, it is called a Payable on Death designation. You may hear the letters POD. Your bank may use different terminology. Do not get stuck on the name. The important question is whether an eligible checking, savings, or other deposit account has a valid death beneficiary designation on file. A properly established POD type designation can allow an eligible account balance to pass to a named beneficiary outside the ordinary probate process, depending on the account arrangement and applicable state law. Non-probate transfers on death and multiple person account structures are specifically addressed within Uniform Law Commission probate frameworks, but this is where careful seniors get trapped. They assume that if their daughter is named in the will, the bank already knows. The bank may not know. They assume that because their son helped them pay bills last year, he will automatically have access after death. He may not. They assume that because they are married, the account automatically works exactly the way they imagine. The actual title and ownership arrangement on the account matter. Consider a typical example. Let's call her Carol. Carol is 74 years old. She has been careful with money her entire life. She keeps about $96,000 between checking and savings at the same bank she has used for nearly 20 years. Carol also has a will. Her daughter Denise is named to receive most of Carol's estate. Denise knows where the will is stored. She knows the name of the bank, and Carol has told her more than once, "Don't worry, everything is handled." Then Carol dies unexpectedly. Within days, Denise is dealing with travel expenses, final household bills, and funeral-related costs. She walks into the bank believing her mother's savings will be available because the will clearly names her. The bank employee pulls up Carol's account. Then the employee looks at the account record again. There is no payable on death beneficiary listed on the savings account. Now understand this carefully. That does not mean the bank simply keeps Carol's money. It does not automatically mean Denise has been disinherited. It means the account may have to be handled as part of Carol's estate under the procedures that apply in her state and to that account. That can mean additional documents, waiting, possible court involvement, or a simplified estate procedure if the estate qualifies under state law. Carol's problem was not that she failed to save. She saved. Her problem was not that she ignored her family. She cared deeply about them. She even made a will. Her mistake was believing the will and the bank's beneficiary record were automatically the same instruction. They were not necessarily the same instruction, and this is why the issue becomes so important after 60, 70, and 80. The financial system is full of separate account records. Your bank has its records, your brokerage has its records, your retirement plan has its records, your insurance company has its records. A document sitting inside your home does not automatically update every separate financial institution. And there are 3 mistakes I want you to check for. The first mistake is having no beneficiary designation on the account at all. Maybe you opened the account 25 years ago. Maybe nobody discussed beneficiaries. Maybe you never reviewed that part of the account again. Do not assume, ask. Because the most dangerous financial mistake is sometimes the one that produces absolutely no warning while you are alive. The second mistake is having an outdated beneficiary. This can be even more dangerous because it gives you a false sense of security. Maybe a former spouse was named years ago. Maybe a brother or sister who has since died is still listed. Maybe one adult child is listed even though your current estate plan treats 3 children differently. The legal effect can depend on the account and applicable state law. That is exactly why memory is not enough. You need to confirm what is actually on the bank's record. The third mistake is confusing a beneficiary with a joint owner. These are not the same thing. Adding an adult child as a joint owner may give that person present ownership or transaction rights while you are still alive, depending on the account agreement and law. A POD beneficiary is generally connected to the transfer at death rather than automatically becoming a current co-owner merely because that person is named as the death beneficiary. That difference matters. Before you add anyone to your bank account as an owner, ask the bank one very direct question. What legal and transaction rights am I giving this person today? Do not change ownership because you are trying to solve a problem you have never clearly defined. Now I want you to do something before this video ends. Open your banking app, look at your online account profile, or take out the documents connected to your bank accounts. Do not look at the balance. Look for the words beneficiary, payable on death, POD, or another death beneficiary field used by your institution. If you cannot find anything, that does not automatically prove there is no beneficiary. It means you do not know, and not knowing is the entire problem. So here is exactly what to do. Step 1. Call your bank using the number on your debit card, bank statement, or official banking app. Do not use a number sent to you in a random text message. Then say this exact sentence. I want to confirm the death beneficiary designation on every deposit account in my name. Then stop talking. Let the employee review the accounts. Step 2. Go through them one at a time. Checking, savings, money market deposit accounts, certificates of deposit. Ask whether each eligible account requires its own beneficiary designation. Do not assume one form you signed years ago automatically covers everything you have at that institution. Step 3. Ask what your bank calls the form. It may be called a payable on death designation, a beneficiary designation, or another institution-specific document. Use the bank's terminology. The name matters less than confirming the actual instruction attached to the actual account. Step 4. Verify the full legal name of every person currently listed. Do not say, I think my daughter is on there. Do not say, my attorney handled all of that. Ask the bank what its record shows. If the bank cannot provide the information by phone, ask what identification you need and make an appointment. Step 5. Ask the question almost nobody thinks to ask. What happens if my primary beneficiary dies before I do? Does the institution allow a contingent beneficiary? Can you name more than one person? Can percentages be specified? What happens under the bank's agreement if one named beneficiary dies first? The backup plan is often where families discover the next missing piece. Step 6. After making a change, ask for written confirmation or documentation showing that the designation was recorded. Keep that information with your important financial records. And tell one trusted person where those records are stored. Now let me warn you about the common mistakes. Do not assume your will automatically updates your bank's beneficiary record. Do not add someone as a joint owner until you understand exactly what rights the account gives that person while you are alive. Do not make assumptions about a minor beneficiary or a person receiving needs-based public benefits without getting state-specific professional advice. And do not treat one bank form as a replacement for a complete estate plan when your financial or family situation is complicated. If you have a blended family, a trust, a beneficiary with special needs, major creditor concerns, business interests, property in multiple states, or serious family conflict, Speak with a qualified estate planning attorney familiar with the law in your state. A simple beneficiary designation can solve a simple account problem. It cannot solve every estate problem. That distinction matters. So here are the key takeaways. Your family knowing where you bank is not the same as your family having immediate legal access to the account after your death. A will is important. But you should not simply assume it has rewritten every beneficiary record held by every financial institution. A payable on death or similar beneficiary designation may help an eligible account transfer directly to a named beneficiary outside ordinary probate, but the exact result depends on applicable law, the account, and your financial institution. The ULC's official materials show that probate law and multiple person account arrangements sit within related but distinct legal frameworks. And the most important action is not guessing, it is confirming. Before this week ends, ask your bank one question. Who is listed to receive this account when I die? If the answer is nobody, if the name is outdated, if the answer is unclear, or if the bank says, we need you to come into the branch. You may have found the missing step before your family had to discover it for you. And remember Carol, she was not careless. She did not ignore her daughter. She simply believed one document had automatically updated a completely separate financial record. That is the kind of mistake careful people make. Tonight, your family may believe everything is handled. By the end of this week, you can know whether it actually is. If you are over 60, tell me in the comments only your age group, 60s, 70s, or 80 plus, and whether you have ever checked the beneficiary designation on your bank account. Do not post your bank name. Do not post an account number. Do not share your social security number or any private financial information. And send this briefing to one person in your family who always says, my will takes care of everything. Because one question at the bank today may save a family from discovering one missing form at the worst possible time.